A federal court just issued a ruling that could reshape how millions of Americans exercise their Second Amendment rights, and most people have no idea it happened. While the media was busy covering politics, the economy, and the latest celebrity controversy, a decision with the potential to directly affect every gun owner in this country quietly came down from the bench. If you carry a firearm for self-defense, if you have ever gone through the exhausting process of applying for a concealed carry permit, or if you plan to exercise your rights in the future, this ruling hits you directly, and the fact that most mainstream outlets barely mentioned it tells you everything you need to know about who benefits from keeping you uninformed. What makes this even more striking is how little coverage it has received. Usually when courts issue major decisions involving constitutional rights and government authority, every outlet in the country weighs in. This time, many Americans are only now hearing about it. But the implications are far bigger than most people realize, and the legal reasoning behind it could eventually influence how courts across the entire nation evaluate permit systems moving forward. One unanimous decision. Not a split, not a narrow majority, but every judge on the panel in agreement, and the ground is already shifting. This is not simply another local legal dispute that affects a handful of people in one jurisdiction. This could be the beginning of a fundamental and nationwide shift in the Second Amendment landscape. If you want to understand what it means for your life, your ability to protect your family, and the future of your rights, stay with me because we are going to break it down completely. No spin, no empty hype, just the facts and what they mean for you personally in the real world. Before we go any further, I want to hear from you. Do you believe Americans should need government permission before exercising a constitutional right, or should that right belong to the people by default? Let me know in the comments below. And if you care about staying informed on major legal developments like this one, hit subscribe and turn on notifications because the updates on this story are going to keep coming fast. To understand why this ruling matters so much, you need to understand how gun permit systems have worked for decades and why so many Americans found them not just frustrating but fundamentally unjust. In many states across the country, citizens who wanted to legally carry a firearm for self-defense had to complete lengthy applications, submit fingerprints, pay fees that sometimes ran into hundreds of dollars, attend mandatory training courses of varying quality, pass background checks, and then wait weeks or even months for a government official to review their file and decide whether to grant approval. The process was deliberately layered. In many cases, it was also deliberately slow. For working people with limited time and money, the barriers were enough to make them give up entirely. That, critics have argued for years, was often exactly the point. Some states went even further than others. In what are called may-issue states, local officials held enormous discretionary power over who could and could not carry. A sheriff or police chief could simply decide that your reason for wanting to carry was not good enough, even self-defense. The most fundamental and obvious justification imaginable was routinely rejected in certain jurisdictions. Denied, no appeal, no clear criteria for what would actually qualify as sufficient. Your constitutional right converted into a bureaucratic favor that could be granted or withheld based entirely on someone else's personal judgment. In some places, wealthy and well-connected applicants sailed through while ordinary citizens were turned away with no explanation. Supporters of these systems argued they promoted public safety. Critics argued they created unconstitutional barriers between citizens and rights already guaranteed to them by the Constitution. That disagreement fueled lawsuits for years. But recently, something fundamental changed in how courts examine these laws. Instead of asking whether a regulation seems reasonable by today's standards, judges have increasingly been asking a different and far more demanding question. Is this type of restriction actually consistent with the historical understanding of the Second Amendment at the time it was ratified? Does it have genuine roots in the tradition of firearms regulation that existed when the Bill of Rights was adopted by the founders? That shift in legal analysis has changed everything, and this latest ruling is one of the clearest and most direct expressions of it yet. The court examined the historical record in serious depth. They studied what the founders actually intended when they wrote the Second Amendment. They reviewed early American practices, English common law traditions, and the broader understanding of the right to bear arms at the time the Constitution was drafted. They looked at what kinds of restrictions did and did not exist in the colonial and founding era. What they found was striking. The historical tradition simply does not support the kind of modern, permitting regime that turns a constitutional right into a multi-step bureaucratic approval process, requiring government sign-off before you can exercise it. The majority opinion was direct and unambiguous. Current permit systems go significantly beyond what history and tradition can justify. In legal terms, that is a devastating and potentially fatal finding for the status quo. Here is the analogy that puts it in plain terms for anyone who wants to think it through clearly. Imagine being told that before you could speak publicly, attend a religious service, or publish your opinions online, you first had to submit an application, pay a government fee, complete an approved course, wait months for a bureaucrat to review your case, and then hope the official looking at your file happened to be in a generous mood that day. Every American would immediately recognize that as an outrageous violation of constitutional rights. The court's reasoning says the exact same principle applies to bearing arms. Rights do not require permission slips. Government cannot condition the exercise of a fundamental constitutional right on a bureaucratic approval system with no historical basis. Now, before we go any further into what this means for your daily life, something important needs to be said clearly, because a great deal of misinformation is already circulating online, and some of it could get people into serious legal trouble. This ruling does not mean you can carry anywhere at any time with zero rules whatsoever. Sensitive locations still carry restrictions. Federal facilities, schools, airports, courthouses, and other specially regulated spaces remain off limits for civilian carry under separate laws that this decision does not touch. Private property rights still stand completely. Business owners retain the right to prohibit firearms on their premises, and that right is not diminished by this ruling. Background checks for firearm purchases remain in place and are entirely unaffected. Federal prohibitions for convicted felons, domestic abusers, and those adjudicated as mentally dangerous continue to apply in full. What the ruling targets specifically is the pre-approval permit system itself, the requirement that law-abiding citizens must first seek government permission and prove their worthiness before exercising a right they already possess by constitutional guarantee. The burden is shifting. Instead of you proving you deserve to carry, the government must now demonstrate that you are specifically disqualified. That is not a subtle legal technicality. That is the fundamental architecture of how constitutional rights are supposed to function in a free society. Another myth spreading rapidly, that this ruling instantly and automatically applies to all 50 states overnight. That is not how the legal system works, and believing it could put you in a genuinely dangerous legal situation. Court decisions apply directly within specific jurisdictions first. Their effects expand over time through subsequent challenges, appeals, and rulings in other circuits. What this decision accomplishes is establishing powerful constitutional reasoning that other courts across the country now have as a foundation to build on. Think of it less like a light switch being flipped and more like the first domino in a very long row. The momentum is real, but the transformation takes time. One more myth worth addressing clearly, that your existing permit is now worthless and you should discard it. That is genuinely bad advice. Existing permits still provide practical value during any transition period. They continue to offer reciprocity benefits in many states that have not yet updated their systems. They can smooth interactions with law enforcement officers who are still operating under previous assumptions and may not be aware of the latest legal developments. Do not throw them away. Understand their current status in your state and use them strategically while the legal landscape settles. Now let me walk you through 3 concrete and realistic scenarios so you can see exactly how this plays out in the real world, not just in a courtroom or a legal brief. Picture the first scenario. You live in a state that has traditionally been May issue. You walk into the sheriff's office, you have done your homework, you explain that you work late shifts in a high crime area, you have a family depending on you, you have no criminal record and never have had one. By every measurable standard, you are exactly the kind of citizen the Second Amendment was written to protect. The official looks at you and says self-defense is not considered sufficient good cause in this jurisdiction. Denied. That kind of arbitrary gatekeeping is precisely what this ruling targets and strikes down. The court made clear that government cannot convert a constitutional right into a discretionary favor that officials hand out when they personally feel like it. The default going forward is that you can carry. The state must now demonstrate through a proper legal process that you meet specific criteria for disqualification, a criminal conviction, a specific court finding, a documented and legally recognized basis, not the other way around. For people in formerly May-issue states, this is the reversal that advocates have been fighting for across generations. The second scenario involves shall-issue states, places that were technically required to issue permits if you met the legal criteria, but still layered on mandatory fees, training courses, fingerprinting, waiting periods, and paperwork designed to make the process slow and discouraging enough that many people simply gave up. The ruling does not prohibit all training requirements, and responsible gun owners should train consistently regardless of what any law demands. The question courts will now ask is whether any given requirement is genuinely rooted in historical tradition or whether it is a modern invention designed primarily to function as a barrier. Requirements that exist mainly to exhaust and discourage law-abiding applicants are now on very shaky constitutional ground. Expect states to begin dropping their most burdensome requirements or face a wave of lawsuits they are increasingly likely to lose. The third scenario is one that keeps many gun owners up at night, and for good reason: interstate travel. You live in a state with strong carry rights, but your work, your family, or simply your life takes you through or into states with very different laws. Not every state falls directly under this ruling yet. Some will move quickly to align, others will resist, passing emergency legislation or rebranding the same requirements under a new name, a public safety certification instead of a permit. The same fees, The same delays, a different label on the door. Courts are watching for exactly these kinds of end runs, and fresh lawsuits will follow every time a state tries one. The reciprocity landscape is going to shift significantly over the coming months. What was clearly legal last month may have new gray areas next month. Use reliable resources like state attorney general websites to stay current, and always verify the specific laws in every state you plan to enter. This ruling accelerates the push toward broader national recognition of carry rights, but do not mistake acceleration for completion. Now, let us talk about the broader ripple effects, because this ruling does not exist in isolation. State legislatures are scrambling to respond. Federal agencies built their enforcement structures around the assumption that most carriers would pass through state permit pipelines. When those pipelines change, data flows, enforcement priorities, and operational procedures all face disruption. And that creates confusion before it creates clarity. Other federal circuits now have a powerful constitutional framework to apply to cases that have been stalled for years. Jurisdictions that once felt untouchable are watching challenges gain new momentum. The attorneys who brought this case are already examining other restrictions. Every case that follows builds on the reasoning established here. Here is what all of this means for you, stripped down to what actually matters in your life. For years, the system treated law-abiding citizens as suspects who needed to prove their worthiness before a government official would allow them to exercise a constitutionally guaranteed right. You had to demonstrate good cause, you had to satisfy bureaucrats, you had to wait and pay and hope, and in may-issue states you could be denied by someone who simply did not believe civilians should carry regardless of what the Constitution says. That era of arbitrary gatekeeping is ending. The right belongs to you by constitutional guarantee. The government's role is to respect that right and to justify any restriction through proper legal process, not to ration it out based on official preference or bureaucratic convenience. But here is the part that gets lost in the excitement of a major legal win, and it matters just as much as everything else said here. Your personal responsibility has increased significantly. With more law-abiding citizens legally carrying in more places, the standards every gun owner holds themselves to matter more than ever before. This is not a green light for recklessness. It is a call to a higher and more visible standard. Train consistently, not because the government mandates it, but because your family and your community deserve a competent and disciplined protector. Know the laws in every jurisdiction you enter. Carry with real situational awareness every single time. The way you exercise this right, the judgment you show, and the responsibility you demonstrate all matter to the culture, to the ongoing legal fight, and to the people around you. The founders wrote the Second Amendment with a clear-eyed understanding that an armed citizenry is the ultimate check on government overreach and the most reliable means of self-defense for ordinary people who cannot afford private security or rely on police response times. A permitting system that forces you to ask permission first fundamentally undermines that principle. This ruling recognizes that. It says the right exists independently of government approval, not as a product of it. The fight is far from finished. Appeals are coming. Some states will attempt creative workarounds. Media coverage will frame this ruling as extreme and dangerous while ignoring the careful historical analysis the court relied upon and the consistent evidence that constitutional carriers are among the most law-abiding groups in American society. That framing is entirely predictable. Now you know to look straight past it. What does this mean for legal cases already sitting in federal courts right now? It means attorneys are calling their clients, reviewing their briefs, and accelerating their timelines. Cases involving waiting periods, storage mandates, and specific ammunition restrictions are all going to get a second look through the lens of this historical analysis framework. The attorneys who litigated this case built an argument that travels well. It does not stay contained to one type of restriction or one state. It moves through the court system the way strong constitutional logic tends to move, by being borrowed, cited, and built upon in case after case until it becomes the settled framework judges everywhere apply by default. Think about what that means for the ordinary gun owner 5 years from now, not for the legal analyst or the Second Amendment scholar, but for the person who just wants to drive to work, pick up their kids, visit family 2 states over, and go through daily life with the ability to protect themselves if the worst moment ever comes. The goal of all this litigation is not to score a legal victory for its own sake. It is to make the normal exercise of a constitutional right actually normal. Not burdensome, not humiliating, not dependent on the mood of a government official, and not requiring you to justify yourself to anyone before doing something the Constitution already says you have every right to do. That is what is at stake in every one of these cases. That is why this ruling matters beyond the legal headlines. If you have been on the fence about getting more involved, paying attention to these cases, supporting the organizations doing this legal work, or simply staying informed about how the law is evolving in your state and nationwide, this is the moment to change that. The legal momentum is real, the direction is clear, but momentum requires people who are paying attention and who care enough to stay engaged over the long term, not just when a big headline drops. Talk about it. Share it with a fellow gun owner who needs to hear it. Stay current as new developments emerge, because they will keep coming. 3 things to carry with you from everything covered here. The burden of justification is moving to where it has always belonged. For too long, law-abiding citizens bore the burden of proving they deserve to exercise a right the Constitution already guarantees them. This ruling corrects that equation at a foundational level. Government must now justify restriction, not citizens justify permission. The permit debate is no longer isolated to one regulation or one state. What began as arguments about carry laws is now part of a much larger and deeper conversation about the limits of government authority to condition the exercise of constitutional rights on bureaucratic compliance. The legal challenges being prepared right now go well beyond permits. The direction is clearly set. Individual responsibility is not optional, and it is not separate from rights. As the legal landscape evolves in your favor, the obligations you carry as a gun owner matter more, not less. Stay informed. Know every applicable law. Train consistently and seriously. Carry with honor and with discipline. Rights and responsibilities are not in tension with each other. They are inseparable, and they always have been. This ruling is a real and significant victory for every law-abiding American who has ever been told that their right to self-defense was a privilege that had to be earned, applied for, and approved by someone else first. But victories require defending, and the people on the other side of this debate are not going away quietly. Neither should you. The attorneys and plaintiffs who brought this case deserve recognition. The citizens who funded this fight deserve to see it carried forward. Stay informed on every update. Stay trained to a real standard. Stay engaged in the process. Stay free.